So Attorney Dorotik, please recap where we are, what's next, and Tim will start our questions following Alex. Thank you.
Thank you, Maureen. I think the best place to start is to talk about what is actually alleged in the case, because that gives the framework for everything that happens from there. So, what is alleged is that when KNC was originally formed, there was an illegal term within the forming documents. And what that means is that they inserted something that legally cannot stand. Specifically, it's the 1,000 votes for the resort area or the beaver pond. Now, and to get a lot of background on this, I would suggest, if you don't know much, to visit the Dissolve-KNC website. That's how I started with this, and it really well lays out sort of why we should be doing this, but also how KNC has broken the law. In Colorado, you can't have a provision of a forming document of what's called the condominium association, but an HOA that gives preference to parts of the HOA that are going to be retained by the ownership. You can't give them a voting preference. You can't give them sort of less dues or anything like that. Everyone has to be treated fairly. And that makes complete sense. It's what we would kind of hope and what we sort of expect. But that's not what's happened here, as is really well laid out on the website. Having 1,000 votes for the resort property means that the resort property can essentially has a veto on any changes to the any of the actual structure of the KNC, and also controls who's elected to the board. So in the case, we simply allege when it happened originally, it was done incorrectly. It's very sort of, from a legal perspective, it's actually quite basic. And we'll get into this more with some of the questions, but nothing that happened today really affects the case, because what is being alleged is when it was formed 20 years ago, it was done incorrectly. This would be similar, to give a good analogy, this would be similar to if Maureen and I contracted for me to buy one of Maureen's kidneys. Most people know you can't sell your kidneys, so it's an illegal contract. It can't be enforced. In the same way, that provision, the 1,000 votes for the resort property, we're alleging cannot be enforced. At current, we filed a complaint, and that's the way you start a lawsuit in Colorado, saying they did this wrong. What KNC has decided to do is try to fight that complaint with a motion to dismiss. Now, their motion to dismiss doesn't address any of the actual merits, but what it says is, well, you're not complying with a bunch of different areas of the law. And of course, they have every right legally to do that, but it is kind of telling, and I'll talk about why, because I know there's questions about sort of the prospects for this lawsuit, but it says, didn't comply with the statute of limitations. Some of the reasons go even more sort of silly. They say that, well, because it's filed on behalf of Dissolve-KNC.org, that we don't know if Dissolve-KNC.org is formed to try to dissolve KNC. So it's kind of laughable almost. And the standing issue, I'm sorry, not the standing issue, the statute of limitations issue is also kind of laughable because, yes, this was done 20 years ago, but when you have an unconscionable term or an illegal term in a contract, it doesn't matter when this happens. It's illegal forever. It was illegal when it was done. So they filed that, we've answered, and we're waiting for the court to decide. Now, the first question most people ask, when's the court going to decide? We don't know. It's been to the court to decide since October. It could come out today. It couldn't come out. It could not come out for another 6 months, and there's not much we can do to control that. The likely next steps, though, and why I say that why Maureen's talking about an appeal when we're not even there yet, is that it's hard for me to see a likelihood that the district court's ruling will be such that the losing side goes, well, you guys win. I don't think we're going to think that if the district court especially says you don't have standing or you didn't follow the statute of limitations, because we have really good arguments as to why that's not so. And I believe I provided our response to their motion to dismiss. That can be obtained through Maureen. She could give it out to anyone. It's a filed document, so it's public record. But it addresses why none of these apply. And so if somehow the district court were to disagree with that, I believe we would be going forward with appeal. Obviously, that's a decision to be made by Dissolve-KNC. But given that we haven't gotten to the merits of this, I would expect that. But I also would expect KNC itself to not just go, well, you guys win, and I guess we'll just get out of the way now. So that's why it's hard for me to imagine a time where, the decision comes down and one side just gives in. The other thing I would note that also makes it more likely is that district courts in Colorado, they handle the law, of course, but they're really more fact-based. And that's especially true in Summit County because you have three district court judges, all of whom worked primarily or solely in the criminal area of the law. So they're just not as well versed in civil or as experienced in civil. I don't want to say they're not as well versed, but it just goes without saying that if you do 90% or 100% of your job for 10 years in one area and then are asked to do a different area, you have more of a learning curve than someone who's already done it. Additionally, the way they distribute cases is sort of at random. And so the judges, because most district court cases are criminal law cases, get mostly criminal law cases. So civil are kind of one off. And this is not an area of the law that most practitioners play in. It would not at all surprise me if the first time that the judge had ever heard about the statute that we're saying says you can't do this with an HOA would be when the lawsuit was filed. So, but the Court of Appeals, on the other hand, has much more resources for legal issues. But this isn't really a factual issue. The facts are not at issue. We know what the facts are, and I don't think either side really disagrees with them. It's whether or not this portion of the founding the founding document violates the law. So the Court of Appeals is more well versed and typically you get a more comprehensive answer, which is why I think both sides would say if you lose, you go, I shouldn't have lost. We're going to the Court of Appeals. And if you win, you go, yeah, I won. But even sometimes when you win, you go, yeah, but this judge didn't really get it. We still need to go to the Court of Appeals. So hopefully that gives you at least a sense of where things are at. And now I'm going to turn it over to Tim for the first of your questions.
Okay, Alex, can you please tell us why you feel that our legal challenge has a positive chance of prevailing, albeit upon appeal? For instance, what similar rulings related to common interest ownership association rules in Colorado support our view?
So I'll start off with, if you want to know the similar rulings, Google Arrabelle Vail lawsuit. And I could, of course, give you the legal site, but most of you not being attorneys, that doesn't help you as much. But Arrabelle, and I checked it earlier, at least for me, Arrabelle, Arrabelle, Vail lawsuit comes right up. And it is a lawsuit involving Vail, where what was actually done was, I would say, a whole lot less egregious than here, but the plaintiff still won. It was a split of the expenses that was charged at about 60-40 when it should have been 50-50. But otherwise, voting seemed relatively equal. So that really walks through how the law is applied and really makes clear that this is much further outside the bounds than the case at hand there. There's another lawsuit which is much harder to find involving Main Street Station Vacation Club versus Main Street Master Association. I can provide a link if anyone's really interested to that, but that was only district court, so it's not quite as comprehensive. So getting to why I'm confident, it's actually probably the easiest way is to say how I got here, which is that Maureen called me up and said, hey, saw that you represented another HOA. We have this issue in Keystone. And we talked for 5 or 10 minutes. And as an attorney, you get those calls and you don't know where anyone's coming from. And then Maureen says, well, I have this website. And I go, great. Because it's much easier for me to take all the time I need to read something and go through. So I say, you know what, why don't I read that and I'll get back to you. And I read through and it's pretty well laid out. It's actually really well laid out. What the provisions of the KNC are and what the law is. And when looking at it, I think, yeah, that makes complete sense. The law makes sense because you don't want someone to retain something of more value and use that against unwitting future purchasers. It's really clear how this applies, and it's really clear that 1,000 votes makes no sense for that resort parcel. And having dealt with Vail in other lawsuits, the brazenness hardly surprised me. So then what I start thinking is, okay, sort of where's the catch? Because that's the damage control I always do is how do I know that Maureen knows what she's doing? What am I missing? So I start looking through case law and I start looking for anything. I have a sort of a brain trust of other attorneys and we bounce cases off each other. And is this as straightforward as it seems? And that's when I came across the Arrabelle at Vail case, which, cases get overruled, everything else. The Arrabelle at Vail case hasn't been touched. In other words, it's still as good a law today as it was when it was published roughly 10 years ago. And there's nothing I see that goes against the very solid logic that I was originally presented with. And so then I start talking to Maureen and we work through how I can represent Dissolve-KNC. But then the other test is this. Whenever I file a lawsuit, and this has happened to me, and then I used to do it quite a bit when I used to work for municipalities, was someone would file a lawsuit and I would call them up and say, hey, your lawsuit has no merit because of this thing. Because some of those things you just don't know about. But it's the easiest get out of jail free. For cities, it involved the Colorado Governmental CGIA, Colorado Governmental Immune, I forget the A. But basically, there's certain procedures you had to follow to sue a municipality, and there are only certain times you can. And so it would knock out a lot of lawsuits that would work just fine against, say, Amazon or Walmart. And I was waiting. I figured I'm going to file this lawsuit, and if I'm wrong, if Dissolve-KNC is wrong, I'm going to get a call from the other attorney, and they're going to say, "Hey, this is why you're wrong." That call never came. Or in the motion to dismiss, it would be very straightforward. It would say, "Yeah, you can't do this because the law is really clear. You don't win." None of that has happened. And if it was there, I would expect it to happen if the other side, the other attorneys had any ability at all. And I'm not saying they do or don't. I don't know them that well, but that's where it's at. So I'm looking at this and there's no reason. It makes sense. The law's on our side, is all the law I can find, and I worked hard, is on our side. The case law is on our side, and the defense hasn't pointed out a single thing that has made me think this isn't a meritorious lawsuit. So that's why I'm confident.
Great. All right, well, let me go ahead with another question then. If the court does agree that the current voting allocation, the 1,000-vote allocation to the resort parcel, so to speak, if the court finds it violates Colorado HOA law, what might the remedy be?
So the courts have a lot of power in equity, and that basically means fairness. That's a fancy legal word, so I get paid more. That really just means fairness. Courts have a lot of power to basically find a fair remedy when part of a contract has to be stricken. Sometimes that fair remedy is just to get rid of the whole thing. So getting back to the analogy where Maureen was going to sell me a kidney, and I was going to mention this earlier because I thought about it a little bit before, to talk about the statute of limitations. I'm kind of jumping around, but if Maureen and I wrote out a contract where she's going to sell me a kidney 5 years ago, and then I say, give me your kidney. And she says, no, I can't say, well, too late. The statute of limitations is run. Now you have to give me a kidney. The law doesn't work that way. In the same sort of way, for that contract, the remedy would be we get rid of the whole thing because there's no fair saving it. There's nothing else. And if I had paid Maureen money, I could sue her for the money back because it's an unenforceable contract. But other than that, I'm never getting that kidney. In this instance, the court has a lot of options. But to me, the easiest and most direct option is you just give the resort parcel half a vote, 1 vote. Anything under 10 will do. And then engage in fair voting. And people like Maureen and Tim maybe become leaders in it, or other people that then reform KNC to then reflect the will of the majority of the voters. That I would be surprised if that wasn't the remedy. That's the remedy. And also, a lot of times when you win these, you get to say what the remedy is because you're trying to find, you're sort of the one already presenting the fair side. And that makes sense. I also think if I were the judge, I'd go, yeah, you can't get rid of the whole thing because there's millions of dollars, there's services, it doesn't work to get rid of it. But if we just get rid of these 1,000 votes, well, that sounds like the result Dissolve-KNC wants and a result that makes sense. So that's what I would expect, but I can't say for sure.
Okay, and Alex, what might be the time frame for an appeal, including how long would it take you to develop your case, and then how long would it take for the Court of Appeals to make a decision?
So the time frame for appeals, again, really hard to give an estimate on because we're still waiting for the judge to rule. Like it could be sitting in my email inbox right now. I'm waiting for the one time I say that it happens. But part of my life is just waiting for judges to rule, and it could happen anytime. From there, once we get a ruling, the side that wants to appeal has 49 days to notice the appeal. The Court of Appeals then sets a briefing schedule, which lasts about 2 or 3 months. And then there may also be oral argument, another 2 or 3, 4 months. And then we're waiting for the Court of Appeals to decide. All told, maybe a year. But the only active part is that briefing schedule and possibly oral argument. There isn't, from my perspective, this case has already been developed. The only sort of expense, so in a lot of cases, you have expenses of doing what's called discovery or interrogatories, depositions. There's nothing that needs to be known here. I specifically wrote it that way because it's really straightforward. It's either when it was written, it was okay, or when it was written, it was not okay. And so there's not really a dispute that it was written. Those documents are, at this point, publicly available. There's not a dispute that the law says what the law says. So it's just, does that apply? So it's not like we would need a lot of time to, hunt down evidence or take depositions or waste a lot of time and money on discovery. In my mind, there's no need for any discovery. There might be some very small needs if the other side does it, but I still don't think so. And my goal is always to get to the resolution as efficiently but as accurately as possible. Here, I don't see discovery. If I take a deposition of someone at Vail and say, what does this document say? All they can do is read it. They weren't there 20 years ago. Or even if I can find the person who does, they could say, yeah, I wrote it that way. What do you want from me? It doesn't change it. So it would just be a waste of time and money to go through that. And they can say, well, it says this, but it really means this. No, it says what it says. It's 1,000 votes.
Great. Yeah, many of the KNC homeowners have raised the issue. This is really a different kind of issue now. And it's more, I think, a question of what we can kind of do while we're letting this all play out. What we can, still do as KNC homeowners, to get more information and perhaps, make a complaint to some of the things we feel that we're blocked from really having any input on. And one of those things is a $4 million payment that KNC has planned on their list of reserve contributions for us to fund in the future. It's a $4 million payment for a snowmelt system on the Kindred's private property. A lot of people are very upset about this, for good reasons. This basically takes all of our annual assessment that all KNC homeowners have contributed this year and hands it off to one HOA in the organization for their own private property. So is it okay for us to sort of, ask for information and to maybe even ask KNC for, to develop a case for why that $4 million payment is congruent with our KNC declaration?
So sort of two different parts to that question. First is, and I think what you're asking is there anything that anyone as Dissolve-KNC can do or can't do that might affect this lawsuit? And the easiest answer to that is there's not a thing that I can reasonably expect you guys to do that can affect this lawsuit. Because this lawsuit is about what happened 20 years ago and about what has already been done. So I cannot imagine anything that, and having spent a little bit of time with Maureen and Tim, they're not crazy. So, yes, if you did I don't know, kidnapped the leader of KNC or something, that even then legally it still has no effect, but it's just a bad idea. But otherwise, there's not a thing you could do. It will not affect anything. So feel free to do things. Feel free to take any action. Nothing will hurt this lawsuit because it's not about anything happening today. We win this lawsuit if the court says, yep, it never should have been written that way. If the court says, yep, you could have written it that way 20 years ago, we lose. And so there's no like, well, it shouldn't have been written that way, but Dave Maureen said this mean thing in a meeting. Doesn't matter. You can do whatever you want. As to current expenditures, to sort of address that, until this case is decided, there's nothing legally that, well, there is a little thing that I'll touch on, but I'm not sure how much you would want to do that because I'm not sure how successful it would be. But from a legal perspective, not a lot that can be done because this is just winding its way through the courts. But you can do anything within your normal power as a member of KNC to go to meetings, to yell, to scream. Whether or not they pay attention to you, I don't know. I can't speak to it. And you may be able to put pressure through the press. None of that has anything to do with the lawsuit. So you can make whatever decision you want. There's, again, nothing you guys can do. Would I go, oh, I wish you wouldn't have done that because now it affects things this way. Again, short of that kidnapping plot, but I don't think we're going to do that. As to what you could do, you could, and I'm not suggesting this, but I want to briefly go over it. You could file what's for a preliminary injunction, meaning we're stopping you from doing this. In order to win a preliminary injunction, 4 things have to be there. You have to show a likelihood of success, which I'd give us a decent shot at. You have to show irreparable harm if this happened. And irreparable harm is generally listed as a harm that cannot be solved through money. And then there's 2 others, like it balances the equities, who's hurt more by it, and whether it's in the public interest. Where I would be worried about is that irreparable harm. Because what the argument I would have to make if I were to handle that is, well, yes, spending this money hurts the organization, but it is just money. But essentially, Dissolve-KNC is kind of suing itself because eventually you're all homeowners. You're sort of suing the larger organization of yourself. And so you can't get that money back. You see where it gets kind of convoluted. I'm not saying that I would, if you said, hey, we really want to do this, I would not, I'm not sure if you'd win, but I wouldn't spend a lot of time talking you out of it because I could see it and it also could get press, which may be helpful. But in general, I'm not nearly as strong as I am on the lawsuit to begin with, because a lot of times courts don't like preliminary injunctions because it's like, no, we'll just handle it all later. And you're making me rush because preliminary injunctions, because you're trying to stop something, is we can't wait till the end. And harder to do that when it's an expenditure of money. I have a lot of sympathy because, as Maureen said, it's $4 million that's just poof in private property, which seems like a crazy expense. So that's what would give it a possibility, but it's certainly not as strong as some others that I've been involved in where it's like, okay, we have to stop this construction from happening because it might cause irreparable damage to this large building. And then you have a little bit more of an argument of buildings falling down versus, well, the money is being spent where it's unwisely.
Good.
But other than that, feel free to do whatever you want.
Okay.
Okay, Alex. The KNC homeowners underwrite both 90% of the KNC manager's salary and the KNC reserves fund that he manages. With this fund now holding more than $15 million, due to the 1,000 vote allocation, though, KNC homeowners are consistently rebuffed from having any input regarding the KNC manager's salary and requirements around his training. From publicly available forms, KNC homeowners can only determine that the manager's compensation falls somewhere between $250,000 and $340,000 annually. The question is this: is there anything KNC homeowners can do now, short of winning our legal challenge, to demand that this manager's training includes financial management training?
So it kind of dovetails with the last question, which is there's nothing you're going to do to hurt anything. I'm not aware of any legal provision within like the articles of incorporation or anything else that require financial management training of the manager. And I'd be really surprised because that would be much more specific than you usually see in those. So I don't see a legal like sort of leg to stand on. So then you get into, well, how can you persuade them? And you all would know better than me. But there's not any legal issue to it. But on the other hand, don't at all be concerned with, well, if we make this noise, I mean, in the end, they're already to sort of release them up. I can't imagine them finding ways to take more advantage of you. And so they're already doing all they can. So it's not like they're going to be like, well, we were going to treat Maureen nicely or Tim nicely or their properties nicely, but now we're not. We're kind of already there, at least within normal reason. So it it certainly makes sense that you'd want that, but there's nothing legally that can be done until the lawsuit comes through, and then you have control, and then you can do whatever you want.
Great. All right, great. I think that's all of our questions. Are there any other points that you feel that you want to make, Alex, or anything else?
I'm trying to think of anything that springs to mind over our conversations, and it really, I'm not coming up with anything. I mean, just really to sum up, this is a very meritorious lawsuit in my mind. It'll be a fight because it's Vail, but given where you're at, you don't have a lot to lose, and you're already losing so much on a annual basis, given that the $4 million just being spent toward something that has no benefit to KNC that's a tough pill to swallow. And all you're asking for is, a lot of us, like I live within an HOA right now. A lot of us do. And we don't agree with everything, but it's never like, well, why did the HOA, buy something across the street that's not part of our property? Or why don't we all have equal votes when the original landowner owns a tiny pocket park? Like that's not what happens in my HOA. I don't really know how it's run, but I spend a little bit of money. There's a pool. It's awesome. Like that's what we kind of expect. We just expect the normalness, and it's never going to be perfect spending, but it shouldn't be like this.
Well, great. Thank you very much. And thank you, Tim. And we will stand by. Obviously, you will let us know as soon as you hear from the court.
Mm-hmm. Yes. And
Very good.
of course. And if anything else comes up, if I, somehow get a call, of course you'll hear from me. If I get a call from the other attorney on the other side, but otherwise we're in a holding pattern. But I'll try to send out, as Maureen asks, I'll send out sort of updates, although a lot of them might just be, hey, we're still in the same place.
Excellent.
Okay, well, thank you, Alex. I think you really cleared up a lot of questions that people might have. I think it's great. Thank you.